Welcome to NYU Law School's Latham and Watkins Forum. Today's program is co-hosted by the Reese Center on Law and Security. I'm Ryan Goodman. I'm a professor here at the law school and faculty co-director of the Reese Center, and I'll be the moderator for today. We have two speakers who need no introduction. They are essentially a dream team for the topic that we have. The selection criteria that we applied was something of a gold standard, looking for individuals who have brilliant minds, sharpest analysis, keen judgment, and with a deep knowledge of the Mueller investigation. And I think if that's your criteria, then the very top of anybody's list would be Preet Bharara and Natasha Bertrand. They are two extraordinary public leaders who have helped guide the country through one of the nation's most difficult legal and political challenges in its history. So Preet, as many of you know, is a distinguished scholar in residence here at NYU and a professor at NYU. He was the United States Attorney at the head of the Southern District of New York from 2009 to 2017, and is the author of a terrific, very new book, Doing Justice, A Prosecutor's Thoughts on Crime, Punishment, and the Rule of Law. Natasha was recently at The Atlantic, is now, I think as of Monday, is that right? The national security correspondent for Politico and is a contributor at MSNBC. I would say that if any of you everybody here is self-selected into this room, and if you're here and you haven't bought Preet's book, then you're doing it wrong. Same goes for listening to his podcast, Stay Tuned, and subscribing to Cafe Insider. Similarly, if you're on Twitter and you don't have Preet and Natasha in your auto notifications, you're also doing it wrong. They just really are incredible individuals at a pressing time in our country, and I think of them as national treasures. So please join me in welcoming both to the forum. Thank you. So I thought I'd just say a few words to set the stage for our topic of the Russia investigations and the way forward. Today's April 17th, 2019. In less than 24 hours, the Mueller report in a redacted form will be released to the country and to the world, and it's almost 2 years to the day when Special Counsel Mueller was appointed by the acting Attorney General, Rod Rosenstein. So in Rod Rosenstein's order on May 17th of 2017, he said, quote, "The Special Counsel is authorized to conduct the investigation confirmed by then FBI Director James Comey in testimony before the House Permanent Select Committee on Intelligence, including any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump and any matters that arose or may arise directly from the investigation." And then a footnote here, everything that he described in that part of the order is about a counterintelligence investigation, and that is exactly what James Comey had testified to when he went before the House committee. So there was a counterintelligence investigation, and the rest of the order says, if the special counsel believes it is necessary and appropriate, the special counsel is authorized to prosecute federal crimes arising from the investigation of these matters. So in other words, a principal mandate of a counterintelligence investigation to look into any kinds of coordination or what has now been called collusion between the Trump campaign and its associates and the Russian government. And then secondarily, any crimes that might pop up in conducting that investigation. So there are two types of questions I thought I would use to try to structure our time together. First are very specific questions about the next 24 hours, what we can anticipate before the release of the report, but then spending a lot more time on some broader themes, looking back at the past, the last 2+ years, and thinking about what lessons they have for the long-term future of the country. So the first question is just the kind of most predictable question for Natasha and Preet, and for whoever would like to begin with it. You know, what do you expect tomorrow? What are the kinds of big unanswered questions that you are hopeful will get resolved? And in thinking about tomorrow, what gaps do you think there are between the public's expectations and what actually might be revealed?
Do you want to start?
Go ahead.
Okay, well, I think we have no idea. It is apparently an almost 400-page report, so I think it's going to outline a little bit more than just the prosecution decisions and declination decisions that Mueller came to over the course of the 2-year investigation. But I also don't necessarily know how much of the report is going to be about counterintelligence findings, because I think that Mueller perceived his mandate within pretty narrow criminal terms. So I think there has been a debate about whether the purview of the special counsel was primarily counterintelligence or primarily criminal. But speaking to Neil Katyal, for example, who wrote the regs, his opinion is that it was never written for, the purposes of a special counsel to have this counterintelligence mandate. It was always going to be a criminal mandate. So, that being said, I suspect that Mueller will kind of keep within those narrow kind of parameters, and to the extent that he does outline details about people that perhaps weren't charged in the investigation, details about, various elements of their interactions with the Russians during the election that may have been discovered over the course of, the broader counterintelligence probe that was being carried out by the FBI agents assisting with the investigation, that will all be redacted if it's in there at all. So I don't think we can expect to learn a lot tomorrow about, who was like Joseph Mifsud, this weird professor who offered the campaign, emails, Hillary Clinton emails in the early days of the election. What was the Trump Tower meeting about? What was Paul Manafort doing with, Konstantin Kilimnik, offering him polling data about the campaign? Those kinds of questions I'm not totally confident will get answered. But I think we can perhaps expect to see a bit more about the obstruction of justice angle of the investigation. And that, of course, is what the president's lawyers now are focusing on responding to. That's apparently going to be the bulk of their counter report, which is, if you believe Rudy Giuliani, stands at about like 35 or 40 pages right now. So,
it's good to be here. Thanks for coming, folks. I agree with Natasha. I don't quite know what we're going to see in the report. I also agree that all eyes will be probably more on the obstruction section of the report than on the conspiracy/collusion section of the report for a couple of reasons. One, on that question, Bob Mueller was a lot more definitive than he was on the second question. He said he doesn't have enough basis to say there was a commission of a crime. There's a better argument that the case is closed there. And along those lines, further to what Natasha said, I would expect that the 4 areas of redaction that Bill Barr has outlined would apply much more to the conspiracy section than to the obstruction section. For example, lots of the things that occurred with respect to the 2016 election interference, you would expect some of those things to have classified information relating to them, and so that's where you will see a lot of redactions. And so what's interesting to me is on the obstruction side, it is the part of the report that is much more worrisome to the president, it's potentially much more damaging to the president, and simultaneously should lend itself to fewer redactions than the first. So one of the first things that I'll be looking for as I preview the document is quickly see how much redaction, other people say censoring, there is on the obstruction side, because from what we have gathered, it seems that a lot of the evidence was either things that happened in plain view, statements made by the president himself on Twitter in interviews with Lester Holt, and also voluntary interviews with folks. Now, there's some legal question, depending on where you are in the country, as to whether a voluntary interview about things then later becomes subject to grand jury secrecy rules if the special counsel decided to put that same witness in the grand jury later. In a lot of circuits, it does not mean that it's then grand jury information, but I'd like to see what the obstruction side says. And the other thing I'd be curious to see is what, if anything, Bill Barr says. So, we know there's going to be a report from the special counsel, redacted in some form. We know there's going to be some counter report that our friend Rudy has pared down to 35 or 40 pages, if you believe the reporting, as Natasha said. But then I wonder what Bill Barr is going to say. I wonder if he's going to say, I'm curious what you folks think, if he is going to put some gloss on it, if he is going to have some transmittal letter that he puts with it, because people will be looking to see how faithful his 4-page summary, which he keeps saying was not a summary, but of course it was a summary, how faithful that is to the underlying report, especially in light of that reporting from the last week or two, which is unusual, that you might have seen, that there are members of the special counsel team who seem to be kind of miffed and have told associates that they're miffed because they believe that the rendering in the summary of the report maybe seemed to minimize what the actual findings were. So we can talk more about what we expect in the report that we haven't seen yet, but I anticipate seeing more on the obstruction side. If we don't see a lot on the obstruction side, then that would make me worry about the good faith of the redactions.
And I guess another question is, along these lines, do you think the public will ever see the report? So you turn on television, there's a lot of punditry saying it will eventually all come out. And I doubt it, especially the counterintelligence parts of it. That might never come out for the public, ever. Not like 4 years from now, but ever. Or do you think that there's a chance that what will happen next in the next phase of, if there are lots of redactions, how does this get litigated? How does Congress try to apply pressure to get the information that might be, let's say, in the grand jury redactions?
Well, I think, so what the House Democrats now are doing anyway is they are fighting tooth and nail to get the classified information that might be redacted from the report, and the intelligence committees say that they actually are entitled to see that classified information because, you know, that's their purview. So my hunch is that if that information went to the Hill and if it was, you know, damaging to the president, or even if it wasn't, then it would probably leak. So I think then that's one way that we can be pretty sure that if that information goes to Congress, the public will eventually see it. And then with regard to the grand jury material, apparently, you know, they're going to go to court and they're going to try to get it that way. But if there's, for some reason they can't, then there's also talk among the Democrats of actually launching impeachment proceedings so that they have that open investigation that may be required, I think it was from the Watergate precedent, in order to get the grand jury material. So, you know, that's another way that perhaps the public might be able to see it. I think it all has to go through the Hill first, but ultimately it might all come out.
Yeah, so, you know, what's interesting about this issue of whether or not material that has classified information or information about sources and methods will come out, you know, we had a very substantial debate and controversy in a different context, but a related context, with a fight over the underlying FISA affidavit relating to Carter Page. And you had a chairman of the House Intelligence Committee and members of the administration not seeming to care so much that there was classified information, and that you've never seen, I think ever, publicly released, forget about the clamor in anticipation of the release, of information like that. And so, you know, in some ways, the line has been breached on this issue. So I agree with Natasha that there are various ways that this may become public. There's potential leaking, which doesn't necessarily mean that the whole document will become public, depending on you know, what the parameters are and the personality of the person who thinks that they're being a whistleblower and want to put the information out into the public. There's litigation. I don't know how long that will take, and it could take longer than the next election. And from what we hear from reporting, is that that's what the president and his lawyers' goals are, to make sure that none of this damaging stuff, to the extent it is, comes out, you know, while he's still seeking re-election. And then there's the thing that also could happen after 2020, and that is a new administration comes in, and suppose it's any one of the Democrats. I think the likelihood is really high, especially since some of those lines have been breached, like I said, in the interests of you know, public understanding, transparency, burying the hatchet, maybe taking up new hatchets, that will become public, because I think there's a lot of rancor around the redaction process. So one way or another, I think at some point in time, it does become public. How much, we don't know.
So another question is, like, how much of the Mueller investigation do you all think has been wrapped up? Have we kind of like seen the end of it in terms of some of the individuals who are kind of associated with the investigation or under the inquiry of the investigation, like Eric Prince, Don Jr., Jerome Corsi? So Jerome Corsi, just to bring people up to speed, was actually released to the public a draft statement of offense that the Mueller's team had given him because he was about to plead guilty. And then he broke out of their cooperation talks and seems to now be walking free, which is that's one of the shocking reasons that there was a surprise as to the wrap-up of the Mueller investigation with no further indictments. Do you think that that is the situation we're in, or do you think that some of these other matters that Mueller gave to other parts of the Justice Department might still follow those threads?
Yeah, maybe Preet can explain the Corsi thinking a bit, because that was pretty shocking, because it allowed Corsi to go out and essentially say, look, the Mueller team was just bluffing the whole time. The prosecutors were just trying to get me to cooperate. This was all a lie. It was all based on a lie. And, so the fact that they actually didn't end up charging him in the end arguably could hurt the prosecutors' reputations in the future, if they try to get witnesses to flip, for example, and the witnesses are like, well, how do I know you'll even charge me? But so that was definitely a surprise. But one of the biggest questions I have, apart from the individuals that are still kind of out there, for example, Erik Prince, the fact that he blatantly lied to Congress. There's no question about that. He lied about the timing of one of his meetings at Trump Tower in 2016. It was very categorical, it was very clear, but he was never actually charged with lying to Congress. And as we know, Mueller was not shy about charging people for lying to Congress. So yeah, weird threads like that, I'm interested to see whether they have been kind of handed off. Like the Roger Stone trial got handed off to DC attorneys, and the trial's set for November now. But I'm also more interested in figuring out whether there's an ongoing counterintelligence investigation. That's obviously something that's very, very difficult to find out, because it's so secretive. But if there's still an ongoing counterintelligence investigation into, anyone in the president's orbit, or even the president himself, what would that even look like? Was it kind of carried out by the FBI agents after they left Mueller's team? Things like that are all up in the air, and there are legal experts now who argue that that is one of the most important questions that Mueller, if he's ever brought to the stand, should answer. But I guess we'll have to wait and see. But yeah, I'm just really interested, first of all, in what you think of the Corsi thing.
So the Corsi thing is very strange, and I don't know quite what went on. There is a standard operating procedure among prosecutors who want to flip someone, to, depending on the circumstances, put pressure on them. And one of the ways you put pressure on them is by revealing some of the information you have and making it clear to them that the best hope they have for, extended periods of liberty going forward is to plead guilty and cooperate, that there's no sense fighting, that the best solution for you and your family is immediate surrender. And so, I've been in rooms many times where you bring the lawyer in, certainly, and sometimes the lawyer comes with the client, the defendant, or the target, and you make clear, here's what's going on, here's what we have, especially if you're trying to get the person to cooperate proactively, so that you don't have to file a public charge. So that happens all the time. And it is also sometimes the case that you go so far as not just, telling the target that you're, toast, to use a legal term, and telling the lawyer the client is, and sometimes, by the way, the lawyer believes that the client is toast, and if you're a good lawyer, they'll bring the client in and say, could you please persuade my client to do the thing that I think is right? And then sometimes that's the best for the budding lawyers out there. Sometimes that's the best representation you can give. Look, you're in trouble, here's what the prosecution has, you should cooperate. And obviously, the defense lawyer and the prosecutor are aligned differently and have different interests, but sometimes there's overlap in that interest, and there's a back and forth that goes on there. And so in that regard, sometimes you will even put up slides, and you'll play a snippet of a tape to convince the target, again, like I said, you're toast. It is very unusual in a criminal, I'm not aware of doing this, in a criminal proceeding as opposed to a civil proceeding, where sometimes you will say to the other side, if you don't meet my demand, and I haven't practiced civil law in a long time, but my recollection is, you might actually draft a complaint that's very well pled and with great particularity, and you'll give it, you're company A, you'll give it to company B and say, we're going to sue you Monday morning, and go to court unless you meet our settlement demand, and that happens all the time. I have not seen an occasion where you give not only the lecture to the target, which must have happened here, but then you give them grist and no way of preventing them from sharing it with the world unless you're really planning to charge. I think in that back and forth, just again, based on my anecdotal experiences and overseeing a lot of people's experiences, you can bluff a little bit. And maybe you're not sure you're going to have enough evidence to charge, and it's early in the process, but you will say, here's how strong the evidence is, and convince them to plead. Once you give them the document, then I think you've given them some ammunition to call your bluff. And again, I don't want to second guess, I don't know all the facts, but it seems like that might have been, a tactical error.
And also, just to add one more data point to it, the statement of offense for Corsi has a lot of similar allegations in it than with the indictment of Roger Stone. So they did seem willing to back up a large part of that.
Because the other part, I want to just add 2 cents on the larger question of what remains. But rather than answer that, I'd like to just mention, what I would like to know if I had a chance to interview Bob Mueller is why he chose to end the investigation when he did. Because I think it is completely and totally legitimate, appropriate, arguable that he could have continued for many months. He didn't have to spin these things off. And I wonder what was going on in his mind and whether he was thinking about just being sick and tired of doing this investigation, understanding that with every day that passed, given the president's proclamations outwardly and also the reporting of what he said on the inside, that his days were limited. And he wanted to be as quick as possible, do the basic bread and butter work of the counterespionage investigation, the stuff relating to Russia, the attendant obstruction investigation. And as soon as he was done with that, Roger Stone still has to go to trial. We still don't know what's going to happen with some of these other folks that you were mentioning. And he just wanted to say, I'm out. He distributed them to other offices. And it may be, like some armchair tacticians suggest, that he was trying to make sure, like, by the way, that Andy McCabe himself said in a slightly different context, that you want to make sure that the investigations you have begun will have life beyond you, and one way to assure that is to spin them off to other places. And if it was a combination of those circumstances that caused him to say, I'm done, and if that's so, then that suggests that there may be more other things that are going on that we don't know about, as opposed to drawing some conclusion that mostly everything is done because Bob Mueller was being exhaustive in the things that he was looking at and only finished when he was on the cusp of being exhaustively done. It doesn't seem like that is so.
Well, and just adding to that, a comment that was made by Andrew Weissman, who's a member of Mueller's team, a couple months back in one of the hearings for Paul Manafort, where he said that a particular episode, the episode where Paul Manafort gave that internal campaign polling data to that suspected Russian spy, Konstantin Kilimnik, that very much went to the heart of what the special counsel was investigating. And so for the investigation to wrap up with no further explanation of what he meant by that, and with Barr summarizing Mueller's comments and Mueller's findings as did not rise to the level of a criminal conspiracy, there's obviously a lot that was kind of just left up in the air. And Rick Gates is still cooperating in ongoing investigations. I mean, he still hasn't been sentenced yet. So I think it's a really, really big question why Mueller chose to wrap this up now. And you could be conspiratorial about it, but I won't go there.
But the other thing, just to, not to pour water on the parade, depending on what your perspective is and whether you're upset that the last season is over, and is there going to be a spin-off, or is the TV series over? I don't know how many other shoes there are to drop. And I do sometimes, wonder whether people spend too much time, sort of hoping there's more stuff because they have a view about the president, and they want lots of other people to be indicted and to go to prison. Maybe that will be so, and I'm sure we'll get to a question about my former office, the Southern District, but maybe it will not be. And to the extent, people have a view about the case that's colored not by the evidence and facts of the case, but is influenced and informed by their perception and feelings towards the president as a leader, people need to separate those two things.
So just to continue with Natasha's question about the potentially ongoing counterintelligence investigation. So we know from the New York Times, and it's confirmed by Andy McCabe, in part in his book, but then in a bunch of the interviews that he did afterwards, that the FBI opened an investigation on the President of the United States soon after James Comey was fired. And then the New York Times also reports that when Mueller came into his position, that he actually took over that part of the counterintelligence investigation. And there hasn't really been any reporting, as Natasha in some sense mentioned, that it ever ended. And my understanding of how these counterintelligence investigations work with different files for different people is that for many of them, they might hardly ever end, or it's going to be several years before the end, because if you think somebody might actually be working on behalf of or under the manipulated influence of a foreign power like Russia, then you might keep that file open for some long period of time. So both for in terms of the president himself and then for some of his associates, Carter Page, even down to that level, and others, do you think that that is still something that's an ongoing part of this? In some sense, I think the American public has been so fixated on the question of, are people going to be locked up? Is it going to be a perp walk? Or are there going to be indictments? Which is, we can just say now, bracket that completely. It's not about crime. Carter Page might never have been charged with a crime because he never committed a crime, but he still might be an unwitting agent of a foreign power. And so that big question about, are there people in the president's orbit, which is a remarkable thing to say, if not the president himself, who are under the influence of Russia to some degree, or Russian interests, Russian pressure, do we think that's still ongoing? Do we think that will the public will get an inkling of that? Will the public get an inkling of that because I suppose Mueller's team and some other parts of the FBI are supposed to brief the Gang of Eight and maybe the full intelligence committees about that part of the investigation? So it sounds as though there's something very ripe there. And maybe so much of our attention has been focused on the law and criminality. What about this particular basket?
Well, I kind of wonder if the reason why certain people actually weren't charged in the end is because maybe they're part of these ongoing counterintelligence matters that, you know, if they are charged, it could mess up some of the ongoing investigations. Just a theory, just something I'm curious about. But, you know, it's interesting that you mentioned the Gang of Eight, because one of the funny anecdotes that Andy McCabe told in his book and then reiterated when I interviewed him was that when the FBI went in, when Andy and Rod Rosenstein went in and briefed the Gang of Eight on the fact that they had opened a counterintelligence investigation into the president, no one batted an eye. Like, not even Devin Nunes was like, whoa, 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 wait. You know, maybe in his head he was, and then he went back to the president, and he told the president that, and that creates a whole lot of other issues. It would actually put a lot of things into perspective. But you know, Mitch McConnell wasn't like, whoa, that's a big deal. You should not do that. Let's back up a second. Let's review this. And I think that is pretty telling of how leading Republicans view the president, and being very careful with my words. And so I wonder if there were these counterintelligence investigations going on, you know, not just into the president, but into people in his orbit, you know, whether that would leak, because the fact that the FBI had this open CI probe into the president did not leak, which is really interesting. And in many ways, that kind of means that they were, you know, on board with it. So I don't know. I mean, I think that, you know, looking back on this, Republicans' role and the oversight will be a big part of a reckoning, I think. But in this instance, it seemed to have been that they were all in agreement that the president might have, you know, posed some kind of threat, either in terms of obstructing the investigation or, on the more extreme end, being an agent of a foreign power.
Yeah, I don't have a lot to add, and those are important things to focus on. Counterintelligence investigations can take, and counterespionage investigations can take a long time. And there may be intel reasons why you don't want to expose them, and sometimes they convert into criminal prosecutions. this is a completely different context, but similar in the sense that we're talking about Russian spies. You know, when I came into office in 2009 as a U.S. attorney in August, the very first major case that I was briefed on was the case of the Russian illegals, the Russian spies, 10 of them, who had been under surveillance in a counterespionage investigation for years, and which includes the people that you heard about the following June 2010, who were arrested, pled guilty, and then there was a spy swap dramatically on a tarmac in Europe. And it was unclear when I was briefed on the case when, if ever, we would bring that case down in a criminal fashion, because there's lots of considerations in spycraft, there's lots of considerations in international relations, and it ended up being the case, for reasons that I can't describe, that we took it down in June. But that might have gone on for a number of more years. So I don't know what the considerations are here. I don't know if there are concerns about the next election, how deep into the morass they are. But yeah, I'm willing to believe that that will continue for some period of time before we know much about it.
And I also suppose that based on the different pieces of this that we've described so far, that Mueller might have also wanted to hand that part off. And there could be, it's hard to know, but that it could have been an interest on his part to report to the Congress as soon as possible about the obstruction issue and to have it occur now rather than during another presidential election.
Yeah, I agree.
So just focusing in on the SDNY and what has become, in a sense, a spin-off case. So the SDNY's investigation, prosecution of the hush money payments as a campaign finance law violation. And you know, many have already said that for the past few months that the president's team is probably most concerned about the SDNY investigation, not the Mueller investigation, in terms of criminal liability. And that's because in the documents that are part of the plea agreement with Michael Cohen and others, it is very clear that the President of the United States, according to those court filings, directed the criminal activity. Now, there's other elements that might still be left open. Did he have knowledge that his direction of that activity was a violation of campaign finance law? And even for lawyers, it's sometimes shocking revelation that in campaign finance law, ignorance of the law is actually an excuse in some sense, so that he had to knowingly do that. And also, did he direct the payments in order to just keep his own personal reputation and his family protected, or was it because he was trying to influence voters? But that seems like a big criminal liability overhanging the president at the very minimum whenever he's no longer in office, then he might be indicted. So the question is, and somewhat to point it to you, Preet, do you think that the SDNY has the ability to make this known to the American public prior to President Trump leaving office? And you know, the big
make what known?
Make it known if they believe that there's enough evidence that he's committed a crime. And you know, the big roadblock here, if they do believe that there's enough evidence that he committed this crime, is the Office of Legal Counsel opinions 1973 and 2000 that say that a sitting president is immune from indictment or prosecution while he's in office, but not after. And that should be binding on the SDNY. But it seems like Ari Melber is picking up every, you know, former head of the SDNY who might think through the question of, is the SDNY, are there any circumstances under which the SDNY, head of the SDNY might say, that doesn't bind me? And you were in an appearance with Benito Romano, and it was a really incredible kind of conversation about that, because it's such a huge and solemn kind of a question to be grappling with. But it seemed as though you did actually come out with the idea that under certain circumstances, I think the example that you used was if the President of the United States shot somebody in broad daylight on Fifth Avenue, right? His own example.
He wouldn't lose votes, but
Right.
he might get indicted.
Exactly. So, but what's the mechanism for that, given that the SDNY is basically bound by the OLC?
Yeah, look, so I'll say a couple of things, and I'm speaking just for myself, although I used to be in that position for 7.5 years, so I have some sense of how the office, not just as leadership, thinks about things. And generally speaking, I would say, whether or not you agree with the policy that's enshrined in this Office of Legal Counsel opinion that a sitting president can't be prosecuted or indicted, that's the policy. And that as a general matter, with the one caveat on this, because everything's on a spectrum. If I have students here, I'm always talking about the spectrum. And if you change some facts and make them more extreme, it makes you wonder about the policy in the first place. And that's what you're referring to with my conversation on Ari Melber's show on television. But generally speaking, a campaign finance violation for which you have significant evidence, I don't think rises to the level of just thumbing your nose at that policy. And then the question that we had in that conversation, and that continues, is, and it's sort of an esoteric one, is the question that the policy is one that, as a general matter, you obey unless the crime is so serious, or is there some other consideration that causes you to make the determination whether you abide by the policy or not? And part of my rationale, if I were sitting in the office and having a discussion with my prosecutors as to whether or not we should flout the guidance or not, and the same way I discussed what Bob Mueller, I think, would not flout the policy, is that when you're talking about something as high stakes as criminally charging whatever you think about the Electoral College, the duly elected President of the United States, and whatever you think about interference, he became the president, and he is the president. He may not be the president in the future, but he is now. And for there to be a criminal action that would already be wildly controversial, even in the absence of a criminal action, everything surrounding the Mueller investigation is incredibly controversial and polarizing. To take the step as an unelected person, one prosecutor, one special counsel, and decide, I am going to bring a charge against a president and not even have on your side the policy of the Justice Department that says that is favored, I think you're buying a lot of trouble, and you're buying a lot of additional polarization. So one reason that you want to obey the policy is because it is the fact that it's a policy, so that people will have faith and confidence that the decision you made to bring a case was not made for political reasons or result-oriented reasons or partisan reasons, but made based on the facts and law. And people will have less confidence in that if they see that there's this policy that you flouted. My exception to that is, it's not really an exception, it goes to the same principle, because if it's a campaign finance violation, I think there's arguments you could make. People will point to the John Edwards case. There's lots of talk that people can engage in to say, well, this is political and it wasn't a serious enough crime, and the only thing that the SDNY wanted was to remove the president. On the other hand, if you have incontrovertible, videotaped evidence of a serious, hypothetically, a serious violent crime committed by the sitting president of the United States, then at least the logic for following that opinion and abiding by it a little bit goes out the window.
So I have a question about that. So my first question is, why is it still just a policy and not, why hasn't this been litigated? And
because we haven't had a president who is engaged in the conduct that would present it
so,
squarely so far.
So if the president went out on Fifth Avenue and shot someone, and the SDNY were to charge him, that would essentially force the issue to be tested.
Yeah, and I'd like to see the president, in the face of videotaped evidence of his murdering somebody in broad daylight, argue the OLC policy. It's untenable. And in fact, I'm not sure he would even be... I think it's really important for certain kinds of investigations, I'll just state it a different way, to believe in the merits of the prosecution. And everyone's presumed innocent, but when you're talking about, and maybe this is one of the reasons that Bob Mueller didn't want to ultimately decide the question of whether or not on obstruction there was a crime committed, because it's important that people have faith and confidence, and rather than believe or disbelieve the decision based on whether you like or dislike the president. So I just think it matters. By the way, the other thing I wanted to say about what the options that are available to the SDNY, again, I'm not saying they would do any of these things, but you can indict the president under seal. I think there's a question about whether the issue is you can't indict the president at all, or you can't actually engage in a prosecution of the president, because the basis for that is it would be crippling to the presidency. If nobody knows about it and it's secret and it's under seal, then it's not arguably crippling to the presidency. The other thing, that if I were there, I would be discussing with my folks if we found significant evidence of a particular kind of crime that we would otherwise charge, is I don't know why putting grand jury information to the side, you wouldn't be able to consider referring it to Congress. I'm not aware of any rule that forbids it on a somewhat common basis, not super common, but it happens. We would investigate something, see evidence of a crime that couldn't be charged federally, and we would sometimes refer it to the DA's office. We sometimes refer things to the Inspector General's office. I had a view that if we discovered misconduct of a certain form, maybe there was some other regulatory agency, or you might even tell companies, corporate victims of some kind of malfeasance that wasn't going to be able to charge criminally. You could, again, within the constraints of 6E and the grand jury secrecy rules, you would say, hey, I have a public role here to be a guardian of public safety and hold people accountable, and I don't see why, I'd be missing something because I haven't studied it closely. I don't see why it wouldn't be at least feasible for the Southern District to do something like what Mueller may have intended to do, not make it public, but deliver it to Congress in the form of a referral.
Just to stay with this for a little bit. So my thought of it is that it's not actually a policy, and policy sounds like too much like it's highly flexible, but rather it's a position of the Office of Legal Counsel what the Constitution prohibits. So it's a view of the Constitution, and therefore I don't even see how there's a mechanism for a U.S. attorney to flout it, because it's not flouting a policy, it's actually saying, I have some constitutional ability to do this, but actually the OLC has said that it's forbidden.
Well, but I don't know how, and that's a better characterization. The policy is sort of a shorthand. And just playing this out hypothetically, if the United States attorney decided that he was going to go in and indict the sitting president, notwithstanding the sort of dated OLC opinion and its interpretation of the Constitution, I'm just trying to understand, once the indictment is filed and the grand jury returns it and you file it in open court, what unfolds thereafter? Does the Attorney General direct the prosecutor to file a Nolly motion because the Department of Justice's position is that that was an unconstitutional action? Do the president's lawyers march into court and say, we agree with this interpretation of the Constitution as embodied in that OLC opinion, and therefore the indictment must be dismissed? I'm just not sure how that would play out.
Right, and interestingly, at that point, it's even too late, because the theory behind the OLC opinion is that it creates this badge of criminality hanging over the president, so that's already happened, which I think is the other piece. If the New York State Attorney General were to file an indictment, and New York State Attorney General is not bound by the OLC opinion whatsoever, just the filing of the indictment would already be a reason why a court might say, okay, you can proceed because the badge of criminality is already there.
Right, but you would have that same litigation. Then you would have the same argument. The president's lawyers would presumably go in and say, this is the best interpretation of the Constitution. Before we get to the merits, before we get to anything else, before you set a trial date, before there's discovery, you have to dismiss the case because this is going to cause a problem for the presidency. And by the way, e.g., the OLC opinion, which we think, whose reasoning we think is good, and the court should adopt.
One other thought I've had on this, it's a puzzle for me, if either of you have a thought of the answer to it, is how Bob Mueller himself was able to reach the question of criminality. If Bob Mueller is operating under the OLC opinion that says you could never indict a sitting president, and there's actually the last footnote of the 2000 OLC opinion says, or under seal, because they worry that the indictment under seal, because it's of a sitting president, would leak. So they said that you can't engage in that risk. How on earth was Bob Mueller able to actually come to a conclusion as to whether or not the president was involved in the crime of coordinating with the Russians or the crime of obstruction? So there seems like there might actually be tomorrow a kind of what I've thought of as a Mueller roadmap for the SDNY, that they can at least internally reach that decision for themselves. Do you see that there, or do you think it's not a puzzle?
So maybe this is a semantic response to your question. There's a distinction between, I think, Bob Mueller saying, I have chosen not to charge the president, or I have chosen to charge the president for the crime of conspiracy or the crime of obstruction. There's a difference between that and stating, and maybe I'm getting this wrong, but stating that based on the evidence we have seen, we cannot declare that the crime of conspiracy was committed. In fact, we say that the crime of conspiracy was not committed. And then in the separate part of the report, in the full glory we'll see tomorrow, but the essence of it, as we understand it from Bill Barr, is we cannot state that the crime of obstruction was committed. I think the language seems to be more like that. It's not clear to me that Bob Mueller ever engaged in an analysis or needed to engage in an analysis of whether or not they're making a decision to charge or not. It's almost like a declaratory statement. And nothing, I don't think anything prohibits, when I go back and look at the opinion, it would be an extraordinary thing to do. I don't think anything prohibits directly someone like the special prosecutor from saying, we leave these issues to other folks, and whether or not the interpretation of the DOJ says one thing versus another thing, I don't think anything prevents him from saying there is sufficient evidence to state that the president committed the crime of obstruction. He didn't find that because he said the question was too close. And maybe I'm being too cute about it, but I do think there's a distinction.
So thinking about the question of the resilience of Department of Justice norms, both looking over the last 2 years and then thinking about the next 2 years and what might be another 6 years of a Trump administration. What do you both think about the thought that there is this thick body of norms, there are thick there are people inside the department that we can trust to abide by the rule of law. They are checks on political abuse. And where this has popped up, for example, are when Matt Whitaker was first appointed as the acting attorney general, Ben Wittes wrote a piece in The Atlantic saying, don't worry, 10 reasons not to worry. He'll be absorbed by Department of Justice norms. There are people around him like Rod Rosenstein and others who believe in the institution, and they will counteract any wrongdoing on his part. Then when Bill Barr submitted his letter, the 4-page letter, and said, for example, that there were no instances in which the senior DOJ officials overrode any demands by Mueller, some people said, see, the Department of Justice norms survive, and we don't need to worry about it. It's, in fact, resilient. So I question that, because after Matt Whitaker left his job, he said, it was reported that he said he knew his primary job was to be willing to, quote, jump on a grenade for the president. And he knew that was his role there for the time that he was the caretaker. And now certain, more evidence has come to light, I guess, about Bill Barr and suspicions. But what should we think about the resilience of the Department of Justice norms? And particularly, if you want to care to talk about any particular individuals and how they've operated in the last 2 years.
So just going back before Matt Whitaker was even on anyone's radar, Rod Rosenstein has, just in my conversations with people in the FBI, former FBI officials, people who were conducting these really sensitive counterintelligence investigations, these very sensitive criminal investigations of Hillary Clinton, of Russia, of Carter Page, et cetera, they will tell you that Rod Rosenstein has done more damage to the institutional norms at DOJ than, you name it. They believe that Rod Rosenstein has pretty much at every point in an effort to appease both the White House and also to kind of keep people at DOJ happy in order to kind of play both sides there, he's kind of plowed through all precedent. And you saw that from kind of the very beginning of his tenure when he was essentially a witness to the president's obstruction of justice, when he wrote the memo that led to Jim Comey's firing. And then fast forward to a couple weeks ago when he helped Bill Barr clear the president of obstruction, even though he was a witness in that obstruction investigation. That's just one example. Other examples are, for example, Rod Rosenstein ordered the Inspector General of DOJ to expand his investigation of how FBI officials conducted the Russia probe in 2016 to include an investigation of whether or not any unauthorized surveillance happened of the campaign, namely whether there was any infiltration of the campaign. And the reason why he did that was because the president was tweeting about it nonstop, was because there was this pressure put on him by the White House to do something, to, without any evidence, without any real basis for these claims, to effectively launch this investigation. So Rod Rosenstein obliged them. Rod Rosenstein also handed over an unprecedented amount of documents related to ongoing investigations to Congress, which then promptly leaked, related to ongoing sensitive matters about, Carter Page, about the FISA process. In an effort to be this kind of political survivor at any cost, and, arguably you could say that this is how he managed to keep his job over the last 2 years. He has, according to the perceptions of everyone who has surrounded these people and been in the rooms for the last 2 years, just totally blown through these norms. And so I think he is someone who's going to have to reckon with that after he leaves DOJ, which is allegedly soon, but he also said he was going to be leaving in the beginning of March, so who knows?
So I think that's a fascinating recitation of all the transgressions by Rod Rosenstein, all of which I completely agree with. On the other side, but Rod Rosenstein is not despised by the Democrats in the House or the Senate. Rod Rosenstein, to my knowledge, was never asked to recuse himself, even though, as Natasha correctly points out, and that I have wondered aloud, is a witness with respect to obstruction. And in fact, the opposite is true. Democrats in the House and Senate, and some of whose staffers I've spoken to directly, had faith and trust in Rod Rosenstein, notwithstanding all these other transgressions. Because why? Because he did do one thing that was good.
He didn't fire Mueller.
He appointed Mueller, right? So, when you talk about the question of norms and whether or not people adhere to norms or don't adhere to norms, you have to think, not to be an armchair psychologist, but you need to think about what is the thing that causes a person to decide to hew to a norm versus blowing the norm off. And those are not things that you find in statutes. And some of this I talk about in the book, which you should purchase. My only plug. One of those things is reputational. And not just generally reputational, but the reputation you have in a community. If there are norms at a U.S. Attorney's office for being ostracized if you do something unethical, well, then the people in that office are less likely to stray from that norm. If, on the other hand, there's no penalty to pay, then people don't do that, and you can get bad conduct. And so the interesting thing about Rod Rosenstein, who's been described as a survivor today, described as a survivor, and not necessarily, I don't think he meant it necessarily as a compliment, I don't know if it was neutral or not, but Jim Comey has referred to him in some document somewhere as a survivor, and he didn't mean that as a compliment. He writes this, what I think is fairly described as a pretextual memo for the reason why Jim Comey had to be fired. And for 7 or 8 days, he found, what the price was of violating the norm among his peers at the Justice Department and former prosecutors who were then alumni of the Justice Department. And, hell hath no fury like that. And so the one thing he did, because I think, my armchair psychology, he cared about his reputation. He cared about a specific reputation he had for being a lawyer's lawyer, and for calling the shots like he saw them, and for being down the middle. I'm not saying he was necessarily all those things, but that was a reputation that, by the way, was very spiffed up when he got to stay from one administration to another. And then he saw the whole world crash on him. And even though on other occasions he tried to figure out ways to mitigate concerns and play to the ear of the president, I think, the outcry was so overwhelming over his memo and the firing of Jim Comey, he resorted to the nuclear option. He put Bob Mueller in place. And I would ask folks on the Hill, aren't you concerned about the conflict? And they all said, as I said at the beginning of my response, yeah, but we think he's going to protect Mueller. And so then you see, depending on how you weave the story, is Rod Rosenstein on the side of good? Is he on the side of something else? Or is he just an opportunistic survivor who does the thing that he can do at the particular time to maintain his position, which is a cynical way of looking at it, but a reasonable thing? And I know Rod, and sort of a friend of mine. But I think among the stories that I would like to hear told after all this is done is the story that Natasha was beginning to tell about why Rod did what he did and what the consequences are of his actions.
And thoughts about the broader question of the DOJ's ability to be resilient in these kinds of times, including that you have a president who prides himself on being a disruptor, and certain things that might be norms are a reason to overturn them, not to keep them. And one of them I think of is the independence of the SDNY from Main Justice. Those are just norms in a certain sense that keeps them as independent as they are. Is that right and a true fear that we should have?
Yeah, I think so. I mean, one of the other things that I do in my spare time is, I chair a task force with the support of the Brennan Center with Governor Christie Todd Whitman, Republicans, a bipartisan task force that talks about norms and talks about how, and has made proposals in connection with figuring out which norms that have been honored in the past are no longer being honored or a threat of being reduced to nostalgia, which of those should be codified into hard laws. And among the things we are proposing are more protections for the special counsel. We're thinking about whether or not there should be more restrictions on the pardon power, although that's difficult to do because it's in the Constitution, the release of tax returns, et cetera. And I think, with every presidency, depending on how the president acts, you have to ask yourself the question, is it time for some of these things that were just norms and where we relied people to play by the rules and on the honor system, do you have to pass something? Do you have to have something in hard statute, whether it's divesting or whether it's tweaking the nepotism law to make sure that the next president can't say, well, I know we passed this law after Bobby Kennedy became the Attorney General and he was the brother of the president. Do we need to make it strong enough to make sure you can't hire at no salary your son-in-law and your daughter who can't be fired and for whom you decide to overrule all sorts of career people and give them sensitive security clearances? I think all those things are in question. It's a little bit hard to enforce in statute a norm of, the independence of the SDNY. That's not written down everywhere. That's a tradition that is upheld, and I think at no time more than today, and I got some grief about the independence of the SDNY when I was in that office, I think people have cause to understand why it's so important to have an office that has a reputation for independence and whose decisions about prosecuting rich and powerful, whether it's a president or not, are more easily believed because of the reputation for independence. I mean, I think you ask anybody today, who would they trust more until the president starts attacking my old office, which is a fear I have. Who do you trust more to make a decision on the merits? Matt Whitaker's Justice Department or the SDNY? I think it'd be overwhelmingly the SDNY. And I think that depends on the people who are in place.
So that also goes to the question of the design of the special counsel regulation that creates this entity. Because the other thought I've had is when you were saying that if you were to compare what the public would say about who do you trust more, the Mueller team or the SDNY, it'd be the SDNY because the Mueller team has been subject to a Twitter feed out of the president that tries, it's already understood. I say the word 13 angry Democrats. Everybody in the room knows what I've just referred to.
He's good at branding.
Yeah, and it's hard for the president to say that there are 13 angry Democrats in the SDNY.
No, it's not. I think, look, I worry about that. When the person with the largest megaphone on earth begins to swift boat anyone, including Bob Mueller, it has an effect, maybe not on the fine folks here, but on tens of millions of people. I mean, if you go back and you compare the Republican statements about the Republican Robert S. Mueller III, including from Newt Gingrich, who basically hailed him a hero and saying I think he said something like, I'm paraphrasing, everyone can relax. Bob Mueller is an upstanding person with integrity, and how quickly that changed from this person who I always remind people of this, and everyone knows this, but it's always stark when you say it. Bob Mueller is not a god. He's not a deity. You don't put him on a pedestal. But he's about as good a person as could have been picked, which is why I referred to Rod Rosenstein's action. We're in a country where we worried that people had the power of the FBI directorship for too long. J. Edgar Hoover had it for 9,700 years. Bob Mueller had it for 10. There's 300 million people in the country, give or take, not all adults. But rather than decide to pick a new FBI director, given the tradition of having change in that office and the worry that people had it for too long, what did Congress do? They did something they could never do on anything else. Immigration reform, right? They passed unanimously a bill. They didn't decide to unanimously appoint someone else to the job, confirm someone else to the job. They extended the statute for 2 more years, this Republican. And now you're telling me a few years later, because he decided to do a job that necessarily would upset some portion of the country, because that's what happens when you decide to undertake something fraught, like investigating the actions of a president, that now he's an SOB? It makes no sense. And I don't see any reason why the president can't do that about the SDNY or any other institution.
Yeah, no, I think that he'll do it no matter what. I mean, especially because now he's kind of like his wires got crossed, and so he doesn't know whether or not it's 13 angry Democrats or whether or not they've exonerated him completely. So it's like, which is it? Have they exonerated you totally, and do you believe that exoneration? Is it, or do you have full faith and confidence that they, did not find evidence of a criminal conspiracy? Because they're good investigators and prosecutors, or are they just on a witch hunt and they're, totally unreliable and we can't have any confidence in what they found? So it's just like, no matter how nonsensical it is, I think that it'll just continue.
Yeah, because he's able to, that's exactly right. And in a court of law, if you made these ridiculous arguments about the credibility of people and cherry-picking things, and they're both terrible and evil, and simultaneously they're right about exonerating me, or the FBI is terrible and they coddled Hillary Clinton. It also is true that only because of the FBI's mistreatment of Hillary Clinton did I become president. Michael Cohen testifies at great length all terrible things about the president. The president says, yeah, he's a liar, 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 told 99 lies, but he was right on collusion. If you tried to make those arguments about the credibility of a witness in court, an average jury might not believe you, but we're not in a court of law. And, in the current environment, given how politically charged things are and how polarized things are, he and his allies can make any argument, as stupid as it would sound, under the normal rules of logic and common sense, and tens of millions of people will agree with it because they believe, incorrectly or not, that the president is being harassed, that people have Trump derangement syndrome, and anybody who speaks out against the president must be wrong and compromised and terrible. And that's just a fact of political debate now.
Although I always go back, just one kind of sliver of hope, that people can still be neutral arbiters of truth. In the Paul Manafort trial, there was one juror who walked in wearing a MAGA hat, wearing, just a diehard Trump supporter, and she thought that the entire Mueller investigation was a witch hunt, and she thought that it was totally unnecessary and totally politically motivated, and she voted to convict Paul Manafort. She said the evidence was overwhelming. There was really nothing that could change her mind, and there was only one lone juror, I believe, that kind of prevented them from convicting him on all counts. So I thought that was an interesting data
great.
point.
And it actually, I think we're both making the same point, and that is that juror would never, I don't think, would have ever come to that conclusion had the debate been here, or had it been on television, or had it been on some forum, because it was a she? Because she, presumably at the trial, was made to understand what the rules of trial are, and was made to understand that you have to deliberate, and was made to understand that you're not allowed to consider character assassination and attacks based on fear and things that are not relevant. And those things were not allowed to come into the courtroom. And so even someone with a MAGA hat who had a predisposed view, in the crucible of the courtroom, understood what the rules of engagement were and understood how you're supposed to go about it. And in that environment that's divorced from all the nonsense and noise and attacks and vitriol and invective that you normally have in those kinds of debates on a campaign stage, that person was able to come around.
So I think we have time for just one more question, and that might be just to focus on the other kind of game in town, which is Congress in D.C., both retrospectively and prospectively. Retrospectively, in terms of how mishandled a large part of the investigations or oversight over the Russia matter has taken place for the past 2 years. What could have been done different? Should we have had a 9/11 commission? Can we learn anything from that at a much broader level for the country? And then second, do each of you hold out hope that under the current leadership and the bipartisanship on the Senate Intelligence Committee that there actually might be a search for the truth and a way in which the public might come together on understanding of what exactly happened or other parts that the Mueller investigation didn't cover? Or do you think that we're still just in this hyper politicized environment where that's not going to take place either.
I think there is a sentiment among Democrats, particularly that a 9/11 style type commission would have been particularly helpful in this situation, and that the country really wasn't served well by there not having been one. But I think there's also, Congress put a lot of faith in Bob Mueller, and that may have been a mistake. And I think Democrats now are also looking back at how much kind of authority they put in Mueller's investigation and his ultimate findings, to the detriment perhaps of having their own kind of, to the extent that they could in a Republican-controlled Congress, their own really solid investigation that covered things that perhaps Bob Mueller could not. So, for example, Adam Schiff now is really getting deep into the Deutsche Bank stuff, into the president's financial history to see whether or not he's been compromised by Russia in any meaningful way. And of course, he wasn't able to do that primarily because of Devin Nunes and primarily because of the obstruction that was happening by Republicans and the kind of interference they were running. But there is, I think, some regret on that side of the aisle, at least, that they weren't able to form that kind of commission. And then with regard to, the supposed bipartisan investigation in the Senate, I think it's a misconception that investigation has been any more thorough or meaningful than HIPC's, House Intel Committee's, was. It's been very secretive, and so we haven't seen as much of it as we saw of the House Intel Committee's probe because that was so public and the fighting was so out in the open. But the Senate Intel Committee has, for better or for worse, been able to maintain this kind of aura of bipartisanship, I think, just by virtue of being so secretive. But, in my own conversations with people on the committee, there have been significant disagreements over how far to go on certain issues, and that has actually blocked them in many instances from going down certain paths that, for example, the Democrats might have wanted to go down, or whatever. So it's all about trade-offs, right? So I guess if their main goal was to conduct a bipartisan investigation into Russia's election interference primarily, and not so much into, or not super into, the idea that the president's campaign might have conspired with Russia, then they might have had a really good investigation. And I think we'll see that at the end of, August. They said their final report will be out. But the idea that it's like this sweeping, large, all-encompassing, comprehensive probe that's being conducted by the Senate, I think we should pump the brakes on that a bit.
I think we only have like a minute left, and I associate myself with all of the remarks that Natasha just made. I think, 9/11 style commission with the right personnel might have been great. And I think with all these things, you see I have this penchant for talking about the importance of the people who are involved. You could have had a House Intelligence Committee conduct itself very differently if Mike Rogers, for example, the former chairman, had been there. Very different person from Devin Nunes, both Republicans. You could have a House Intel Committee now conducting itself a lot, I think, less well than it's being conducted if you didn't have Adam Schiff there. And I think one of the reasons the 9/11 Commission worked as well as it did is because the chair and the vice chair, I think, were upright and honorable people, and there was a view that they wanted to get to the bottom of what happened and make real proposals for protecting the country going forward, which is why almost uniquely among commissions of that sort, you see them every once in a while, like the Church Commission, that a lot of those things were adopted. We have a Department of Homeland Security because of that. We have a National Security Division within the Department of Justice because of that work. So if you could have put together a group of people who had their sights on something more important than partisan victory, and it was not about blame, I think that would have been possible. The problem here is, unlike with the 9/11 Commission, really, although there was some, blameworthiness talked about there, whether there was proper discussion between the intel community and the criminal community, but it was really not a finger-pointing exercise. And to the extent you could do something like a commission that's not a finger-pointing exercise, you're going to get consensus and constructive proposals. The problem is that inherently, because of the smoke that was put up here and all the indicia of bad conduct and perhaps collusion, as the lay person says it, there was no way for this not to be, in part, some kind of a finger-pointing exercise, because some people did bad stuff. Some people are going to prison because they did bad stuff. And it's hard, I don't mean to sound pessimistic, but it's hard when you have that kind of conduct to keep it, above the fray, although I think it was maybe possible.
Great. Well, thank you both. It's really been tremendous to have this conversation. Thanks.